Why should a client care that their solicitor's constantly learning?
You need to know, and you need to know immediately. You do not want to spend years of your life pursuing a claim which has no merit.
Medical negligence, do you think is that something that you think is particularly affected by changes?
You don't want to find out at trial that your solicitor didn't know the law.
And do you think that specialising in a particular field like clinical negligence helps you to stay up to date?
The days of the generalist solicitor who covers every part of the law, I think, are over.
Hello, and welcome to today's episode of Medical Negligence Matters. Today we're going to be talking about keeping up to date with the law and why it matters. And with me today is my friend and colleague, Alan Mendham. Hi, Alan.
Hi, Gillian.
Hi, thanks for being here. So the law, it's our stock in trade as solicitors. You've been practicing for quite a few years now. And how's the law changed in that time?
The basic framework for clinical negligence law hasn't changed very much in that we have to show substandard care, so care that no ordinary clinician would provide, and that care caused an injury. But it's changes around that really affect our clients.
Yeah, it's quite a slow-moving thing, the law, generally, isn't it? I guess that the law on medical negligence isn't written down anywhere in any sort of act of parliament or a statute, is it? It's something that has evolved over years, generally quite slowly, but then occasionally there's, somebody throws a rock into the pond and there's a huge change. And it's just medical negligence. Do you think is that something that you think is particularly affected by changes?
I think that all areas of the law are affected by changes. We have to deal with changes to medicine as well as changes to law, of course, which is probably unique in the field of law. But there have been some big changes in recent years to things around the subject, and we've dealt with those within the firm, things like secondary victims claims, which was quite a big change.
Yeah, I think so. So the general framework remains fundamentally the same, isn't it? As you said, we have to show that somehow the care fell below the minimum standard, and that comes out of case law that's sort of decades old, and it's that refinement, I guess, that happens over the years in terms of cases that get decided individually. Medical negligence cases tend to be very unique, aren't they, really? It's the facts that are important in many cases rather than...
Yeah, the individual medical treatment that you receive is tailored to you, and so the facts of your case have to be applied to the law. It isn't a one-size-fits-all.
And can you think of anything? Is there any changes recently that have significantly altered how your cases are handled?
So recently there's been a case where lost years were approached. Now, lost years is an unusual concept to understand. So if your life expectancy is reduced, you may have lost the ability to earn money during the period that you will now no longer be with us. And so it's possible to make a claim for what's called lost years. And until very recently, that could only be done by adults. So you had a really artificial distinction where if you bought a claim as a 17-year-old, you could not make a claim for lost years, whereas if you waited until you're 18, you could.
So what was the thinking behind that? Why adults and not children?
Well, the thinking was it was too speculative for a child, whereas it wasn't for an adult. But of course, it's all speculation as to what somebody's future earnings are going to be, what their career is going to be.
It's a question of degree, isn't it?
How much
I suppose.
they're going to earn.
Yeah, with children, I guess, who haven't started their careers, it's perhaps even more of a leap of a sort of guesswork rather than.
Yeah, but when we make claims for children, who've suffered an injury and we look at what their earnings capacity is, we have to do that anyway. We have to assess what they would have earned but for the injury. And so assessing what they would earn after their death is just an extension of that. And we were able to do that for adults, so there was no logical reason why you couldn't do it for children, and that's what the Supreme Court have recently decided. And so practically, that's been a big change.
So I suppose so for many clients, that's actually a positive change, isn't it? But changes in the law aren't necessarily always positive, are they, in terms of the advice that we have to give to our clients?
No, they're not. And we've mentioned before secondary victims. And now the claim for a secondary victim is if you've witnessed something happening to a loved one and you've suffered a psychiatric injury as a result. Now, the law in this grew up from the Hillsborough Stadium disaster.
So there's people seeing on television the sort of injuries to their family members, loved ones?
Yeah. Some people witnessed in the stadium, some people witnessed things on television, and some people came to the hospital and found injured loved ones. And so tests were developed for the secondary victim cases. And for many years, we were able to bring secondary victim cases for the families of those who'd been injured. But, and this was a negative change, the Supreme Court recently decided that you can no longer bring a claim for a secondary victim in a clinical negligence setting. It has to have arisen from an accident. Now, that was a very hard thing because it meant that we had to tell a lot of clients that actually the law no longer recognises the claim that you had, which was perfectly valid last week, but now no longer exists. So changes in the law do cut both ways.
Yeah, and from a practical point of view, I mean, that's, as you say, there's cases, not only in our office, but in solicitors' offices all across the country, which, as I say, one day was a valid claim, suddenly the law changes and it isn't. So there's some changes that are all to do with actually the principle of the case and whether or not you can bring a claim. There are other cases which I suppose, when I'm thinking about recent changes, where the change has focused more on perhaps the way a claim is calculated.
Yeah, so recently there have been changes around what's called the personal injury discount rate. Now, the idea behind this is if you had a loss that runs for 10 years and it's £100 a year, I don't say 10 years at £100 is £1,000, because if I give you £1,000 today, you can invest that.
So you then end up getting more money than you've lost.
Exactly. You'd be overcompensated. So the personal injury discount rate is an approach which takes into account both the effect of inflation and the ability to invest that money so you get a return. And for many years it was set at 2.5%, and that really wasn't enough. Because it assumed that you would be able to get a rate of return on investments 2.5% above inflation. Then all of a sudden, the government made an announcement that it was dropping way below that, and it meant that overnight the value of cases increased, and so we had to be alive to, are there offers on cases, recalculate what the losses are. Do we need to revisit offers that we've made or the defendants made? But there was another practical effect which I don't think had been thought of, which was changing that discount rate meant that the way that you approach accommodation claims no longer worked. And I remember being in the car when the announcement was made on the way to a meeting with one of our colleagues, Tammy, and we formulated a plan of how we were going to deal with it. Whilst we were driving somewhere to a meeting, and we were able to come back to the office in the afternoon and say to everyone, this has happened, this is what we need to do. Actually,
that's interesting, because I was just going to move on perhaps a little bit to think, well, you know, all these changes in the law can have quite seismic effects on our clients' cases. And thinking about what does keeping up to date look like on a day-to-day basis within a firm like Gadsby Wicks?
So things like when there's a case like the recent lost years case, we knew that that had been heard in the Supreme Court, so we were able to subscribe to an update from the Supreme Court, so we knew when the judgment was coming. And what we were able to do was to assess which cases it was going to affect and how it would affect them. So we knew which cases to be alive to and what the result would mean. The personal injury discount rate, we were able to communicate that to everyone immediately, and so that everyone could then, using tools that we've invested in, reassess their cases.
That's true, because I mean, a change, although the changes tend to happen fairly slowly, when they happen, the effect is as you sort of said, instantaneous. And so our clients' cases, particularly, for example, if a case is coming up for settlement, we have to react quickly to that change.
An offer that might have been a really good offer 6 months ago now looks like a bad offer, or vice versa. And that can happen overnight, and you've got to be alive to it. And that's why keeping on top of changes is so important.
And as a partner in the firm, how do you make sure that all the others in the team are staying informed and up to date with what's going on?
Well, we're quite lucky in that we meet every day as a team. So if there is something that needs to be dealt with absolutely immediately, we can deal with it in a meeting together, discuss it, how we approach that change. And that's in addition to our weekly training meetings. So we see each other all the time, we meet all the time. So we're able to communicate in real time when there is a change.
Yeah, I mean, that's it, isn't it? I think that it's so important that knowledge is shared throughout the team, because none of us work entirely in isolation on our cases. And I think no matter how experienced you are and how many years you've been working in the field, having others around you who are equally specialised and who are equally committed to staying up to date, it makes it a much nicer way to practice, isn't it, really? And what do you think in terms of impact on the clients? How does the sort of staying up to date directly impact them, do you think?
I think as a client, you need to be sure that your lawyer knows what the correct claim is to bring, because if you bring a claim which doesn't have merit or no longer has merit, there's been a change, you need to know, and you need to know immediately. You do not want to spend years of your life pursuing a claim which has no merit. Equally, if there's been a change which means there is now something more that needs to be added to your claim, either another allegation of negligence because something's changed or the value has changed, you need to know, because you do not want your client to be undercompensated, and you don't want your client to pursue a case that they're not going to win.
And so the implications for the firm of not staying up to date are quite significant, aren't they, really? I mean, not from a personal reputation point of view, but in terms of making sure, I mean, we like to give our clients the best possible advice, don't we? We like to be certain that the advice that we are giving is as good as it can be, and that means being completely up to date. And I think it's interesting you touch on the negative elements as well, and I think that is important, isn't it? Because there's no point. Sometimes giving clients negative advice is hard, isn't it?
It is.
It's difficult. But it's important that it's done, because people don't, as you say, want to invest years of their life in pursuing claims that aren't going to be successful. So that is an important part of it. From a client's point of view, why should a client care that their solicitor's constantly learning?
You don't want to find out at trial that your solicitor didn't know the law, because that would be a very chastening experience for everyone. You want your case to be done quickly and for the correct amount of compensation. And ensuring that the solicitor knows the law is the best way of doing that. And
do you think that specialising in a particular field like clinical negligence helps you to stay up to date?
Oh, for sure. I would not have the first idea how to bring a claim for a back injury because someone's breached the manual handling regulations. I couldn't draft a will, but I can do a clinical negligence case because that's all I do, and I keep up to date with that. You can't keep up to date with everything. The days of the generalist solicitor who covers every part of the law, I think, are over.
So for clients listening to this, what reassurance can you give about the firm's approach to staying current?
I joined the firm over 20 years ago, and the first thing that impressed me was the amount that we invest, both in terms of money and time, in training. And that's medical training and legal training, because it is twin track for a clinical negligence lawyer. You have to know when there's a change in the medicine, so as well as a change in the law, because both will change and the claim you're bringing will change as a result. So I think the amount of time and money we invest in training, external training courses, residential, we all disappear off on residential courses for a few days, a couple of times a year. We have external speakers come in, medical and legal speakers come in to keep us up to date. We have weekly training meetings. So we are doing everything that we can to keep up to date as a firm.
And to ensure that our clients are getting the best possible advice and service that we can give them.
Absolutely.
And we get the satisfaction of knowing that we're doing the best job that we can do.
Yeah.
That's great, Alan. We've covered a lot of material today, but I'm really grateful to you for your help with that. Thanks very much.
Thank you.